Thanks, Zach. Well, breaking in just the last hour, an officer who got fired for shooting a woman during a training demonstration will not get a disability pension. Lee Coel lost his job after the deadly Citizens Academy shooting. Wink News reporter Brooke Schaefer is live in Punta Gorda with the breaking details. Brooke.
Yeah, Channing, just moments ago, a board here inside Punta Gorda City Hall voted unanimously that Lee Coel is not eligible for disability pension because he was fired by the Punta Gorda Police Department. Now, Coel claims that he suffers PTSD after police say he shot and killed 73-year-old Mary Knowlton at a Shoot Don't Shoot demonstration last year. This right here is chilling video of the moment he pulled the trigger on a gun that was loaded with real bullets instead of blanks. Now, he was fired back in March, but today his attorney arguing that Coel should still be eligible for disability pension because he filed his application before he was fired. Meanwhile, here's what the attorney for the Police Officers Pension Board had to say just moments ago.
I think the board followed the provisions in the pension plan, and I think they properly applied it to the facts that we have in this case.
And now, Channing, the board still has to meet one more time before that decision is finalized, but no word yet on when that meeting will happen. Coel does face felony manslaughter charges in connection with that shooting. Live in Punta Gorda, Brooke Schaefer, Wink News now.
Order. Maybe we have a roll call, please.
Sam Kibbers.
Here.
Adam Cummings. Joseph Angelini.
Here.
Thomas Ford.
Here.
And Larry Schrader.
Present. Thank you. Item number 2 on the agenda, citizen comments. Is there anybody in the audience that would like to make a comment this morning before we begin? Hearing none, our sole purpose of the meeting today is to discuss an application for a disability pension by Lee Coel. I notice Lee's not in the audience. Is he planning to attend this morning or not? He will not be here. All right. I guess I'll turn it over to our attorney then.
Okay, good morning. My name is Scott Christensen of the firm of Christensen Diener from Sarasota, and my firm represents your Board of Trustees of the City of Punta Gorda Police Officers, our retirement system. So I'm here this morning to assist the board in making a decision with regard to, or at least a preliminary decision with regard to Mr. Coel's disability application. We should probably note for the record that Mr. Brantley, James Brantley, is here representing Mr. Coel, correct, Mr. Brantley? So, so we have a complete record of who's here. What I'd like to do to start off the proceeding this morning is to go through the procedure that we use for processing disability claims. And while everything I say this morning is not going to be immediately pertinent, I think it's appropriate for the board to understand the procedure that we normally use with regard to processing a disability claim, okay? So what I'm going to do is go through the process that we have in our operating rules and procedures in Rule 14, which is the claims procedures that we use for processing not only disability claims, but also any other claim that someone might make to the Board of Trustees if they have an issue with a pension benefit or whatever the case may be, okay? So with regard to processing a disability claim, typically the claim begins with the filing of an application for disability retirement. Okay, we have a form for that application, and you have a copy of that in the records that we sent to you. And by the way, we did provide a number of documents to the Board of Trustees, and Mr. Brantley got copies of all of that as well. To include definitions from the plan, disability provisions, our claims procedures, the disability application, and then a number of pieces of, or a number of other documents that were associated with the city's processing of Mr. Coel's termination of employment from the city. So that's all has been provided to the board and also to Mr. Brantley. So anyway, we'll get back to the procedure. The procedure begins with the filing of an application for a disability pension. All right. That application is signed by the applicant. He is required to attach to that application a letter or some document from a doctor indicating, in the doctor's opinion, the individual is totally and permanently unable to provide useful and efficient service as a police officer to the department. Once we get that application with the appropriate letter attached, then typically we would then do send out to the claimant a set of interrogatories, a questionnaire, if you will. The questionnaire would ask questions about if the disability is based on a disease, when the disease, when the disease started. If it's based on an injury, when the injury occurred. And then we ask a number of other questions in the interrogatories about treating physicians and any pre-existing conditions, just information that gives us what we need in order to process the disability claim and collect the appropriate records. Once the claimant fills out that application, fills out the interrogatories, they're sworn. He also fills out and signs a number of copies of a medical authorization form. The medical authorization form is designed to be signed by the claimant and provided to my office, and it gives my office the authority to collect medical records in connection with the case. Okay. The claimant fills out the interrogatories, signs the medical authorization forms, and sends them back to my office. Then we immediately turn around and we send out requests to all the healthcare providers, be it a hospital, doctor, whatever the case may be, and request records, copies of the records that they have using those medical authorization forms that we received from the claimant. All right. We also at this point send to the city and request copies of any workman's compensation claims, copies of the personnel records, a copy of the job description that the individual is doing, basically, again, putting together the record that we'll need to consider the disability claim. Once we get all those records back in our office, then we set up an independent medical evaluation with a doctor who has expertise in the area around which the claim revolves. So it's an orthopedic claim. We send them to an orthopedic surgeon. In this case, at some point, if we get to the point where we're processing the case on its merits, we will send him to a doctor who has expertise in probably a psychiatrist, because the claim that we have is based on post-traumatic stress disorder. So a psychiatrist would be an appropriate doctor to send him to. So we set up the independent medical evaluation, and we notify the claimant that he needs to attend, go see the doctor. The doctor then receives copies of all of the records that we've collected in connection with the case. At that point, we also send copies of all the records to the claimant so that the claimant can see what we've collected, and he has the right to supplement those records. If he feels we need additional records that we haven't collected, he can certainly supplement that record. And of course, then we send a copy to the doctor doing the independent medical evaluation so that he can see all the treatment that's been done, and he has that as a baseline to go in when he makes his evaluation with regard to the claimant. We also, at that point, would typically send those documents to the board so the board could begin reviewing the records that we've collected in connection with the claim. Okay. Once the claimant goes to the independent medical evaluation, we get the report from that doctor. And then we set up actually where we are today, the initial hearing. And at this hearing today, we're going to back off here in a minute because we haven't collected any records. The only issue that we are going to discuss today is the claimant, is Lee Coel still eligible to receive or be considered for a disability pension in light of the fact that his employment was terminated by the city for non-medical, basically, misconduct or disciplinary reasons, okay, not associated with any medical issue. And I make that assertion based on the records that you all have received, okay? So that's the only thing we're doing today. We're not doing all this process that I've talked about, but this is the initial hearing. So at this initial hearing, the board is going to make a decision, hopefully, make a decision to determine whether Lee Coel still has an opportunity to be considered for a disability pension from the pension plan in light of the fact that his employment was terminated. So that's where we are. We're at the initial hearing stage. All right. The initial hearing stage, if a decision is made today, if the board were to make a decision that no, he's not eligible to receive, to be considered for a disability pension, then the claimant would have a right to request a formal evidentiary hearing back before the board. And this is the process that we have in the operating rules that you all have a copy of, okay? So if he's denied at the initial hearing stage, then they have to request a hearing back before this board, and we would have another hearing and reconsider the decision that the board made based on any additional evidence that the claimant might wish to provide to us. But then we would have another hearing, and the board would again make a decision as to whether the claimant has a right to be considered for a disability pension based on the fact that employment has been terminated, or maybe they would find that based on new evidence or some other issue that in fact the claimant does have a right to be considered for a disability pension. Okay? Now, if the board at the second hearing determines no, he's still not eligible to be considered for a disability pension, then the only recourse that the claimant would have would be to appeal the decision of the board to a circuit court judge or judges. The circuit court, you all probably are aware that the circuit court is basically a trial court, but they do have some jurisdiction, some appellate jurisdiction, and this is one of those. And so the appellate judge, or in this case the circuit judge who acts as an appellate judge, would review the record that was before the board and make a decision as to whether the decision by the board was supported by competent substantial evidence and was in line with the law that's applicable to the particular case. Okay? That's done by a petition for writ of certiorari, and that is essentially, as I say, an appellate proceeding whereby a petition is filed to the judge. The judge reviews it, says there may be an issue here, and then would request or require that the board would have to respond to the petition for writ of certiorari, and we would have an appellate proceeding, still only on that issue as to whether he is eligible to be considered for a disability pension. Still not getting to what we call the merits of the case, okay? Not getting to the issue as to whether he's actually disabled or not. All right? So if in fact we go and we do the appellate proceeding, and the board's decision to deny the eligibility for disability pension, if the court upholds the board's decision, then essentially we would be through. There's a potential appeal from that court decision, but it's fairly limited. All right. If, on the other hand, the judge at that proceeding would find that the board erred in its decision to not consider Mr. Cole's application for disability pension on the merits, then the court would send that case back to the board and say, okay, board, you erred in finding that he wasn't eligible to be considered for a disability pension, so now you need to do what you would normally do in processing a normal disability claim in line with the procedures that I went through earlier. We would then do the interrogatories, we would do the independent medical evaluation, collect all the records, everything that I described initially. Okay? So that's kind of where we are. Everyone understand what the procedure is? All right. Let's look at the particular case that we have. We all, I think, are well aware that the disability that we're talking about arose, or the basis for the disability arose from the shooting incident that occurred back in August of 2016, wherein concerning the death of Mary Knowlton. All right. After that shooting incident, Mr. Cole, I believe, was placed on administrative leave. And he was on leave for some months. Again, we're talking about August of 16. In February of 2017, Mr. Cole filed an application to this board for a disability pension, claiming that the incident, the shooting incident, basically caused him to suffer from post-traumatic stress disorder. Okay, so we got that application back in February of 2017. Along the same, during that same period of time, of course, the city was investigating the circumstances surrounding the shooting, and in March of 2017, about a month after the application for disability pension was received, Philip Wickstrom, the HR manager for the city, after determining all the facts involved in the case, decided that Mr. Cole's employment would be terminated because of the circumstances surrounding the shooting incident. He indicated that Mr. Cole had a right to have that decision appealed to the city manager, Mr. Koenig, and in fact he did do that. He appealed it to Mr. Koenig, and there was a hearing held. I believe Mr. Brantley represented him through this procedure as well. And at the end of the hearing, Mr. Koenig upheld the termination of employment decision made by Mr. Wickstrom in a fairly lengthy order, setting forth, I thought it was very well done, but he essentially denied the appeal. And as a result of that, as of May 25th of 2017, Mr. Cole's termination of employment became final. At this point, of course, we on the pension side we know that this procedure is going on, and since the employment status of Mr. Coel is important and highly relevant to his ability to receive or not receive a disability pension, we were waiting to see what the final decision by the city was. Once that decision was rendered, we made known to Mr. Brantley, or Mr. Coel through Mr. Brantley, that in fact, because his employment had been terminated by the city for non-medical reasons, that in fact he was no longer eligible to receive a disability pension. Okay? So how did we conclude that? And again, now we get to the issue that we're here for today, the limited issue of whether he is eligible to be considered for a disability pension in light of his termination. So what I'd like to first look at is in the records the disability provisions that are found on page 4. The disability provisions, this is section 8 right out of the pension plan, all right? And what it says is that any member who shall become totally and permanently disabled to the extent that he's unable by reason of a medically determinable physical or mental impairment to render useful and efficient service as a police officer basically has a right to a disability pension. In Mr. Coel's case, since he only had a little over 3 years of service, I think he's only eligible for an in-line duty disability pension, not all right, it goes on, that same section goes on to describe what the benefit is if in fact a disability pension is awarded. But then it starts and says, and this is very important and is to me the controlling language that we have to deal with today, it says terminated persons, either vested or non-vested, are not eligible for disability benefits. All right? Terminated persons, either vested or non-vested, are not eligible for disability benefits. It goes on to, and that's the general rule, right? It goes on to express an exception to that general rule, and it says, notwithstanding the previous sentence, if a member is terminated by the city for medical reasons, well, we can stop right there, because that exception doesn't apply because Mr. Coel was not terminated for medical reasons. He was terminated because of the incident, the shooting incident, and presumably misconduct associated with that incident. So the general rule applies, and that general rule, again, is that terminated persons, he's non-vested, are not eligible for disability benefits. So at that point, his eligibility to be considered for a disability pension stopped, right? And we informed Mr. Brantley that, in fact, that was the case. And Mr. Brantley, I think he responded. You have copies of the correspondence in the file, or in the information that we provided to you. Mr. Brantley said we either want to move forward with the disability and process it normally, or if our position is that his termination made him ineligible, he requested an initial hearing on that issue, and that's why we're here today. So that is essentially where we are and what we're here today to consider. And again, I point out we are not considering any medical evidence because we haven't even collected medical evidence yet. The only issue is this eligibility for disability pension, or to be considered for disability pension. All right. The one other thing that I'd like to point out to you, and back to the disability section that we talked about, it starts off by saying any member, capital M, member, any member who shall become totally and permanently disabled. Okay? And this is further support for the loss of eligibility, if you will, for a disability pension if in fact somebody is terminated. Because the definition of member is, and if you look in the definition section, the definition of a member for our plan is an actively employed police officer who fulfills the prescribed membership requirements. Okay, well, certainly when Mr. Coel's employment was terminated, he's no longer an actively employed police officer, right? Police officer is defined as an actively employed full-time person employed by the city as a certified police officer. So he's not a member anymore. So I think that's further support for the position that, in fact, once he's terminated for medical reasons, he's not a member anymore, and he's a terminated person, so he's not eligible to be considered for a disability pension. So that's essentially, I think, where we are today, and that's the comments that I have initially. I would recommend that we give Mr. Brantley an opportunity to be heard on the issue, and then we can open it up for board discussion.
Thank you. Mr. Brantley?
Mr. Chairman, trustees, I appreciate the opportunity to address this issue today. We're here on Officer Lee Cole's application, February 4th, 2017 application for disability pension in accordance with the plan documents that govern the Punta Gorda Police Officer's retirement plan. I want to start with a couple of things. First, the documents that you've been provided previously, we have an objection to some of, and I want to raise that objection on the record. I don't think they're relevant, and I don't believe that they, as I will explain in a moment, that they have any relevance to these proceedings today. Specifically, Cities Exhibit 5 and 6, and the first 7 letters in your packet running up into April, all deal with the city's decision to terminate Officer Cole's employment and his appeal of that termination. Those two, that process and that procedure are separate and apart from what you're dealing with here, and I'll explain that momentarily. So the fact that Officer Cole was terminated, depending on the date, may have had relevance had it occurred before he made application, but it didn't. He didn't. His application was in 35 days before he was terminated. And so his appeal of that, what we consider to be an unjust termination of his employment, was a legal right of his and does not extinguish his right to disability pension benefits. What we sought at that time is for him to be treated like all other city employees who were similarly affected, and that he be returned to status as a full-time police officer and placed on administrative leave pending the outcome of either the criminal charges or, in this case, a determination of his disability pension. That was not done. He was treated differently than other city employees, and we raised that to the extent that that process allowed us, which it really didn't. It put the final decision back in the hands of the very people that made it to begin with. It was not reviewed by an outside neutral third-party arbitrator. But nonetheless, those proceedings are separate and apart from what we're dealing with today. I want to start by making clear, and I'm a little concerned when I see the documents mixed as they are, and I want to remind the board of a couple of things. Section 185.31 of Florida statute says that each board of trustee shall be independent of the municipality or special fire control district for which it serves as board of trustees. It's very important in these proceedings that this board understand that this board and its responsibilities are not married to the city. They are not a subset of the city, and they are not to be controlled or representative of the city's interest. And in fact, Section 112.656 of the Florida statute says that, quote, the fiduciary, which all of you are in managing this pension plan, shall discharge his or her duties with respect to the plan solely in the interest of the participants and the beneficiaries for the exclusive purpose of providing benefits to participants. That's your responsibility as a trustee to the pension plan, and we would ask that that be the framework for what we do today. Regardless of what personal feelings you or other people may have about the August 16th events, Officer Cole was a full-time police officer when when the incident occurred. I don't think there's any question about that. He was a full-time police officer when he was diagnosed with PTSD. He was a full-time police officer when he made application to the city for a disability pension. He has a right to have that application for disability pension entertained in the normal course of this pension board's duties. The language that Mr. Christensen is relying on to suggest that Officer Cole is not eligible for his disability pension is language that this issue that we're talking about today, this conflict between his interpretation and mine, has already been litigated. And it's been litigated through the Fort Myers police officer's pension plan in 2010, a denial that occurred in 2010 on almost identical facts, where the pension board there, using the exact same language, it's boilerplate language, not a single word different between the language in that plan and this one, in which an officer was diagnosed with PTSD after a series of shooting incidents, applied for disability pension, and in that case was terminated by the police chief a matter of days later, 4 or 5 days later, not 35. And the pension board there refused to take up his application for disability pension, and we ended up going through the process that Mr. Christensen just described to you, and we ended up in this very circuit court. And Judge Keith Kyle, and I have copies of that decision I'd like to put into the record today for your consideration. And on the last page of that decision, number 15, again, using this exact same argument. And by the way, even the same language contained and referenced in the application for disability pension was in both. The court said, the court finds that the board's determination that Officer Martinez was not eligible for disability benefits because he was terminated after he applied for benefits is contrary to law, as well as their own plan and procedures. This issue is well-settled law now. To the extent that we are forced to jump through these hoops again and re-argue this, I can tell you that we will seek attorney's fees and costs because we will deem this to be frivolous. This issue has already been litigated. A decision's been made. And if you take Mr. Christensen's argument to its logical conclusion, you end up with an absurd result. What his interpretation of language says is this: you as a pension board could take in any disability pension application, hold it, and sit on it. Let the city terminate the employee and never have to pay a disability pension. Especially in a city here where terminations by the police chief are not reviewable by anybody other than the people that make the decision. There's no right in this collective bargaining agreement for terminations to be reviewed by an outside neutral third party who can make a binding decision. The city makes the determination to terminate, and the city reviews that decision to decide if their decision was proper or not. I think most of us can figure out where those decisions are going to land. So it would be an absurd result to suggest that every time someone puts in a disability pension application, all the city has to do is terminate them, and they would never have to pay a disability pension. And the court agreed with that. That language that's in that plan is a protective language for the plan and makes perfectly good sense. That someone, once they're terminated, can't then turn in an application for a disability pension after the fact. That makes perfectly good sense. And that's not what happened here. In fact, on February 4th, when Lee Coel completed his disability pension application and accompanied it with the required 2 medical providers certifying that he was, in fact, in accordance with the language established in your plan, was disabled, did meet the definition of disability, which is the starting point for that application. He wasn't even aware that he was being considered for possible disciplinary action. That letter didn't come until later in February. Mr. Wickstrom's letter notifying him that he was now under investigation and they were considering potential disciplinary action against him didn't come for weeks after he had already applied. We ask you, and here's another interesting thing about this. If you look in those procedures and in your plan documents that you were just directed to, that language in that same paragraph suggests that the process that we're doing now is designed to be completed in around 90 days. We are now sitting at 150 days, and we still haven't sent interrogatories. We still have not asked Officer Coel for medical release so we can gather information. We have not scheduled him for an independent medical review. This idea that you can sit on a pension application indefinitely and then wait until someone's terminated to avoid paying disability pension benefits is absurd. And the court has already said that result is absurd. And didn't say that a court someplace else didn't say that. Not in New Jersey, not in California, not elsewhere in Florida. This very circuit court, on a case from Fort Myers, reviewing the exact same language on nearly the exact same facts, has already said you cannot deny taking up his application based on that language. That language is contemplated to prevent someone who is terminated from then completing an application for disability pension. That didn't happen here. Once his application's in, all applications take time to process. What occurs after his application is irrelevant if he was an active member of the plan at the time he filed for his disability pension benefits, and that's what Judge Keith Kyle in this circuit has already said. We ask you respectfully to move this process forward. Let's not have this ridiculous legal fight again. And let's process his application. He has done what the plan requires. He has provided certification from 2 medical providers certifying that as a result of an on-duty incident, he has PTSD that rendered him at the time incapable of providing service as a police officer, useful service to the police officer in the city of Punta Gorda. That's all that was required for him to qualify for a disability pension. The fact that the city made a decision to terminate his employment after that is wholly irrelevant. What we're talking about starting now should have already been done. Let's move forward with getting the medical release, sending the interrogatories, getting him scheduled for an independent medical exam, which is the right and the responsibility of this board to do. And then if there's questions, bring it back for a full hearing where we can take up the recommendations of your independent medical analysis as a whole with the record, with the 2 certifications we've already provided, and decide if he does or does not qualify for disability pension benefits under the plan that he was a member of when he applied. I thank you for your time.
Thank you. It's my understanding that the case in Fort Myers is not identical to this case.
Well, if you look at on page 15 of the records that I provided to you, which is Mr. Cole's application for disability pension, and look at the language at the bottom, and then look on page 6 of the order that, by the way, the application was actually attached to the order here, Mr. Brown, but we don't have that. But it does indicate on page 6 what the language was in Fort Myers. And it says in the application in Fort Myers, it said this application must be submitted prior to your termination from the city, except that if you are terminated for medical reasons and so forth. All right, you can see that that is not the same language that appears at the bottom of the new application that was filed by Mr. Cole. And that's because in light of the case in Fort Myers, which I handled, we redrafted the language on the application form to make it clear that in fact, if you're no longer employed by the city, you're not eligible for a disability pension. And so that's why, the applications are not the same. And in fact, the language in the plan is actually not the same. The language that says terminated persons, either vested or non-vested, are not eligible for disability pension. That language was in both plans. But the additional language with regard to the exception for processing a claim based on the city terminating for medical reasons, that was redrafted as well, and that was largely as a result of that case as well. So the situations are not exactly the same. The language is not exactly the same, and if you read this order, you can see that Judge Kyle relied heavily on the words that he found in that application, and that's why we revised it.
I'd like to respond to that. The controlling language that you're to rule on today is not in the application. The controlling language is in the plan. And Mr. Christian just admitted that that language, terminated persons, either vested or not eligible, was identical in both plans. And that was the nail that the city there and this hung its hat on. He explained earlier the whole exception thing doesn't apply here. We would agree with that. He wasn't terminated for medical reasons. So we can ignore whether there were nuanced differences between the exception language. We're not talking about the exception language. He said that that didn't apply. The language of the plan that the court relied on was identical in both plans. And if you look at the paragraph above on the last page of the order from the Fort Myers case, Judge Kyle says, neither section 62-78, which was the corresponding plan document reference from Fort Myers, nor the form explicitly states that once you are terminated, you are no longer eligible. Same here. He said, and then, he says, in fact, when section 6278 is read in conjunction with the form, both imply that you must apply for disability benefits prior to termination. That's the same thing your current form says. Your current form says that to apply, let me turn to that. If you are no longer employed by the city, it says the same thing a different way. You are not eligible for a disability benefit. He didn't apply for a benefit after he was terminated. He applied for the benefit before he was terminated, even before he was notified that he was that he was going to be subjected to disciplinary action.
Mr. Bentley, you said that he was not aware of disciplinary action, but doesn't being put on administrative leave imply that there is some concern about your actions?
He was put on administrative leave pending the investigation. Same as the police chief, who I understand is back gainfully employed here. So no, until he received the notice from Mr. Wickstrom late in February notifying him of potential disciplinary action. That letter that's in your packet.
I don't think anybody knowing that they're on administrative leave knows something is in the works.
They could have been fully exonerated, and from our position, it should have been. But nonetheless, if that were the case, then why would Mr. Wickstrom later in February have to provide him the letter that's in your packet that says, this is your notice of potential, not even a decision, but potential disciplinary action?
Probably because he was dealing with a lawyer, I don't know.
Well, to the extent that we're talking about enforcing the language of this plan, it is judged on a legal basis.
Comments from the board?
Yeah, you already said that was what I was going to bring up. I was going to echo what you just said about potential of him being, he knew.
Excuse me, I need everyone to speak into their microphones. Sorry. So it carries.
All right, Joe, would you repeat, please?
Yeah, I was going to, that was one of mine. I was going to bring up what you already came up with. I was going to echo what you were saying about him potentially knowing that there was something in the works.
Real quick, this Martinez case, was he terminated for medical reasons or something?
No, he was terminated for misconduct, and just like here, that decision was being appealed at the time he filled out his application.
Sorry? You got to be at the podium.
You got to get to the microphone.
Officer Martinez was not terminated for medical reasons. He was terminated for alleged misconduct and had filed a grievance over his termination at the time that he and he had actually filed at the encouragement of his superiors, filed for the disability pension. Again, mirroring exactly what had happened here. And he was ultimately terminated 4 or 5 days after he applied for his disability pension, terminated for misconduct.
Was his medical reasons related to what he was fired for in this case? I haven't had a chance to read this. So.
Our position there was that all of it was interconnected, that his misconduct was in part and parcel a result of his PTSD that he had been suffering off and on. At the end of the day, he was granted his disability pension once the board took his, after we went through the legal fight, and the board took his application up on its merits, he was granted his disability pension.
Any other comments from the board?
Yeah, I have a comment. I want to clarify that we're dealing strictly with whether or not he was eligible to apply for benefits.
Whether he's eligible to be considered for benefits. He definitely applied, and he was eligible to apply when he applied. But because of his termination of employment, he's no longer eligible to receive disability benefits. That's the position that I'm
I guess we do agree that he was eligible when he did apply.
Absolutely. Yep. He was a police officer at the time that he applied. But again, taking you back to the language in the plan, there's no exception. It says terminated persons, either vested or non-vested, are not eligible for disability benefits. At this point, he's a terminated person, so he's not eligible for disability benefits. And like I said, I think the case in Fort Myers can be, the facts are different. I think the language is different, like I said, in the application. And I don't think that case is controlling on you today.
We have a decision the board needs to make, and that is Lee Coel eligible to apply for disability, or to be considered for his disability pension at this point in time? We already know that he's applied, and we've clarified that now. The next step is he eligible to be considered for the pension? Which
we could probably add to that in light of the fact that his employment
was
terminated for
right.
non-medical reasons.
Right. Joey?
Yeah, I'll start by reading what we're listening in the language here. I'm saying no, he doesn't fit it.
You willing to make a motion?
I can make a motion to that.
All right. Would you state your motion, please?
Just deny.
Your state in your words.
May I suggest some language?
Yes.
Okay. If you're saying that you want to deny it based on the fact that he was terminated.
Right. Yes. Correct.
Okay. So the motion could appropriately be that we find that, or we deny his application for disability pension because his employment as a police officer has been terminated for non-medical disciplinary reasons.
Are you comfortable with that, Joe?
I'm comfortable with that, yes.
All right, I have a motion on the floor. Do I have a second?
Motion dies.
Motion dies.
Well, the alternative would, of course, be to find that Mr. Coel is still eligible to be considered for a disability pension. And if you make that decision, then we will start to process the disability claim on its merits.
Well, let's go back to the incident for a minute. Supposedly, Lee Coel had no problems at that time, right, in terms of post-traumatic stress syndrome. Is that correct?
At what time?
At the time of the incident.
August 9th.
I think the determination was that it resulted after that. As a result.
Okay. Well,
You need to go to the microphone, Jim, please. Again, this is an informal hearing, so that's...
okay. Now, from what I understand, he was terminated because of that incident before he had any post-traumatic stress symptoms.
That's not correct. He had made application. He had already been diagnosed and was being treated while he was off on administrative leave while the city conducted its investigation. And during that time, it was determined that he was disabled, and he filled out in February 4th his application for disability pension based on the PTSD that resulted from that incident. He wasn't terminated until March 10th.
But he was terminated because of that incident, so effective at the time of incident, the city really did not want him on the police force because the city felt he was incompetent as a police officer.
Well, I think it took months of investigation for them to get to that point. I hope they didn't know that on the day of that incident that they didn't want him on the force. I don't know. Certainly, there's no evidence to suggest that at all.
Okay. But the ultimate conclusion was, as a result of that incident that day, he should no longer be there. In the meantime, he has developed post-traumatic stress symptoms.
All at a time that he was still employed with the city of Punta Gorda as a police officer, full-time police officer.
So when was he diagnosed with that?
The letters are attached to his application. There's 2 certifications he was being treated by them. I don't know if they outline when the treatment started, but his application has 2 certifications, one from a psychiatrist, DO, and the other from his therapist.
Page 16 and 17 in the package.
Which, by the way, he was required to obtain to file. His application for disability pension has to be accompanied by those certifications, and they were.
So, Mr. Brantley, you're saying that he was a member when he did apply for it. He was a member when he was treated.
That's correct. And I don't think anybody's disputing that this arose out of an on-duty incident that occurred August 2016.
And you also claim that he was a member when the diagnosis was rendered.
That's correct. I don't think there's any dispute of that. He was a member until March 10th when he was terminated.
Now, the fact that he's not a member now, does that have any bearing on whether he deserves to receive benefits from this organization or not?
We would argue that it doesn't, as long as he made application while he was a member. What occurred after that is irrelevant, and that's what the court has said.
We are not providing benefits for anybody who's not a member of the police force, though, are we? I mean, to the best of my knowledge, everyone who is receiving disability benefits, and we had a case just a few years ago.
That's retired.
He left his membership because of the disability.
Right.
The actions that led to Cole's discharge were prior to any of these symptoms developing.
Correct.
Well, Scott, why don't you weigh in on this thing a little bit here and help us clarify.
I think I've already weighed in on it. Like I said, I think the language in the plan is clear. I don't think the case in Fort Myers is controlling on your decision. And I've indicated that, there's no exception in the plan language that says as long as you applied for a disability pension before you were terminated by the city for non-medical reasons, you have a right to continue to have your benefit, your disability application processed and considered by the board. Nothing in there says that. Okay? It says terminated, I know I keep saying it over and over, but terminated persons, either vested or non-vested, are not eligible for disability benefits. And there is an exception for medical termination, but there is no exception for a non-medical termination, and that's what this is.
And he was not terminated for medical reasons.
No, he wasn't. That's why we provided, Mr. Brantley objected to the records that I provided, but the reason we provided those records is to establish that, in fact, he was terminated for something other than medical reasons.
Right.
And that's why I went with that motion.
You want to resubmit the motion?
Well, can you read the motion? I'm sorry, do you have a comment, Mr. Ford?
Right.
Can the secretary read back the motion?
Yeah, I guess I would like to make a comment. I guess this decision is being made on regardless of how fair or unfair we think that is in terms of the treatment.
I think we have to apply the provisions of the pension plan as it's written. Okay, so there's no fair or unfair associated with the circumstances involved. It's a matter of, does his termination and the language in the plan give rise to the fact that he's no longer eligible for the benefit?
In other words, do we believe the language or don't we? And if we believe the language, why shouldn't we support the language that's in this plan that we're here to administer?
I think you have a legal duty to support and apply the language that's found in the pension plan. I don't think your fiduciary duty allows you to make a judgment about whether you think the effect of the language in the pension plan is unfair and therefore you're not going to apply it. Make sense?
Yes, thank you for clarifying that. I'd like to see the motion reintroduced as well.
Let's see.
All right.
Do you want me to read it?
Please.
Mr. Angelini moved to deny Mr. Cole's application for a disability pension due to the fact that his employment as a police officer was terminated for non-medical disciplinary reasons.
All right, would you reintroduce that motion, Joe?
Introduced.
All right, I have a motion on the floor. Do I have a second?
I will second.
All right, I have a motion and a second. All in favor? Raise your hand. Aye. So carried.
Unanimous.
Unanimous. The application has been denied based upon the legal interpretation of the pension.
Okay, just to remind you now, what
Document.
happens is that I will do an order that essentially lays out the action that y'all took and the reason for it, and then that order will be provided to Mr. Grantley, and then Mr. Grantley will, on behalf of his client, have an opportunity to come back before this board and again make a case for reversing your decision, if you will, and convincing the board that in fact he should be eligible to be considered for a disability pension.
I'm not sure I agree that we have to come back a second time. If the board issues a final order now,
Well, our procedure requires 2 hearings.
I don't know that I don't know. I'll have to look at it. I don't know that we're prohibited from going to circuit court on this one. It's a final order.
Well, it's not final.
Okay. Would you speak into the microphone, please, so we can record that?
I will have to look at the procedures. I'm not sure I agree with Mr. Christensen yet that once this board issues an order on that we were forced to come back here a second time for a second order before we're able to appeal to the circuit court. I don't know that I agree with that. That may be correct, but it may not be.
All right. So noted. Next item on the agenda, comments from the audience or additional comments from the board. Hearing none, I'd like to have a motion for adjournment.
Make a motion.
Second?
I second.
All in favor? Aye. Meeting adjourned.
All new on Wink News at 6.
The chief has been doing a PR campaign about, I'm open, I'm honest, anything you want to talk about. Well, he doesn't want to talk about these other incidents. He didn't release these other incidents until you had to go digging through like a madman to find them.
Wink News pushes to get memos from the Punta Gorda Police Department about Lee Cole, the cop who shot 73-year-old Mary Knowlton during a shoot, don't shoot citizens demonstration back in August. These are memos that have never been made public before.
And tonight we'll tell you about the memo from an officer who trains other cops witnessing Lee Cole making what she basically calls a wrongful arrest. Wink News investigative reporter Dave Colbreth has the exclusive.
This sort of stuff should be unacceptable in any law enforcement agency.
He was a one-man wrecking crew in Punta Gorda, and nobody tried to stop him.
Is he fabricating things? Is he making things up just to make the arrest?
3 longtime Charlotte County attorneys, all who have also been prosecutors in their career, read this memo about an arrest made by Lee Cole, which the Punta Gorda police never released until Wink News spent a great deal of effort and hundreds of dollars.
Just shows that the Punta Gorda Police Department was hiding this stuff. Every news agency in the country was asking for these type of documents.
The memo really hit home for Steve Leskovich because it was about his client, Jacob Hill.
You always hear about corruption, but then to actually read it and know that it happens to someone you know is actually quite disheartening.
On June 23, 2015, Officer Bonnie Buckaloo sent this memo to the Punta Gorda Police administrators.
They knew roughly 8 hours after this arrest.
Buckaloo, along with another officer, came upon Lee Cole, who had pulled Hill over for driving the wrong way on this one-way street. First, Cole had his dog sniff around the vehicle for drugs, but it did not detect any. After that, Cole said that he was changing hats and now going to try for a DUI.
He's fishing for something.
Buckaloo also wrote that Cole did not ask any of the related DUI questions and that she did not observe anything that would indicate an impaired driver.
Falling over, stumbling, no odor of alcohol, no bloodshot, watery eyes. None of that information is written anywhere in any of the reports.
Buckaloo summed it up by writing that Cole performed the requested sobriety exercises without any notable concerns, and that he probably should not have been placed under arrest.
It's shocking to read an officer's report that says another officer was seeking or finding a reason to make an arrest. Why is he even arrested?
Apparently, that's also what people in the state attorney's office wondered, because Wink News obtained these documents from them, where a prosecutor writes, "I do not see how there was enough for a DUI arrest, and if that's out, then there's no probable cause to search."
I would bet $1,000 the state attorney had no idea that there was another officer on scene who believes that this was a false arrest.
So, the state attorney's office started playing Let's Make a Deal and said it would drop 5 of the 7 charges, including 2 felonies and the DUI.
DUI getting dropped almost never. I mean, it is a very, very rare circumstance.
I can count on one hand how many times a DUI has been dismissed prior to charges being filed. This is one of them.
When the state attorney's office offered to drop most of the charges, Jacob Hill pled to minor possession of weed and got out of jail immediately.
He pled to those because he was in jail for 35 days and he needed to get out. Who's not going to take that?
Wink News talked to Jacob Hill, who lost his driver's license for a whole year, his apartment, and his job.
And now when he's looking for employment, what shows up on his background? A DUI. Who the heck's going to hire somebody with that kind of record?
So, what did the Punta Gorda police do about this memo? It said it was successfully prosecuted with the means of a plea.
And I have to tell you this. Any department that defines this as a successful prosecution, they should all resign.
Without asking, the Punta Gorda police also gave us emails saying things like, "Buckaloo seems to have an obvious dislike for Lee Cole," stating to other officers that she refuses to acknowledge him or back him up on traffic stops.
She's one of their current own. She's part of the blue line. You don't cross it. She crossed it.
Would he have taken that plea had you known about this email, this memo?
Absolutely not.
When I talked with Jacob Hill, he said he came down here because he's a roofer and needed to work year-round. Well, after all this, he said no one would hire him, so he had to go back to northern Minnesota, and he said, try making a living there doing roofing in the winter. When we asked the Punta Gorda police for an interview, we were told the chief will not be providing an interview on the memo you referenced, continuing the public discussion of Officer Cole's work product prior to the conclusion of both FDLE's investigation and our own internal investigation is unfair and possibly improper on our end. That memo, as well as last night's story regarding those other memos, are on our website at winknews.com. Dave Culbreth, Wink News Now.
I think that that was a sign of just arrogance. I mean, you don't need to double and triple check yourself. You don't need to have other people double and triple check you. You don't have to have a procedure in place. You don't have to make sure. Like, all of those things just make me sick to my stomach.
On August 9th, 3 dozen people watched as a Punta Gorda police officer shot and killed a woman during a Citizens Academy demonstration. Officer Lee Cole's still on paid administrative leave after the death of 73-year-old Mary Knowlton. But could it have been prevented?
Tonight, only Wink News has memos that were not in Cole's personnel file. After weeks of requests and hundreds of dollars spent, Punta Gorda police finally gave us those memos with allegations of bad arrests, insubordination, and policy violation. Wink News investigative reporter Dave Colbreth has the details.
Nobody should be running around this town with a gun and a badge with these type of allegations against them.
No self-respecting law enforcement agency that I've ever encountered should be tolerating this kind of behavior.
Those are two longtime Charlotte County attorneys. Both of them were shocked when I showed them these memos obtained by Wink News after the Punta Gorda police fought hard to prevent us from getting them.
Just shows that the Punta Gorda Police Department was hiding this stuff. Every news agency in the country was asking for these type of documents.
These new memos show Lee Cole's problems with the Punta Gorda police. But Cole's problems started in his rookie year with the Miramar police, where he was involved in 2 internal affairs investigations. This one, where he yanked a man out of the back of his cruiser. After just 1 year, Cole was forced to resign. He then applied for jobs at over 2 dozen police agencies near Miami. Wink News obtained Cole's application files from most of them, who turned him down. So he then redirected his efforts to Southwest Florida, where the only agency interested in him was Punta Gorda. It was a year after he left Miramar when Cole was hired by Punta Gorda.
Miramar got it right. The other 25 police departments that refused to hire him got it right. Punta Gorda got it wrong.
Cole's personnel file with the Punta Gorda police shows many positive things he's done. But then there's these newly obtained memos that were not in his personnel file.
When you hire somebody that was asked to resign from a different police force, they should be on thin ice.
The first incident Wink News discovered is depicted in this memo. It was February 4th, 2015, when Cole accidentally discharged his taser at home. He was never disciplined.
To have an officer not check his taser before he does a spark test, that is Barney Fife stuff.
On October 23, 2015, a supervisor, Thomas Keegan, wrote this memo saying Cole was insubordinate to him and questioned his authority.
I think that him being insubordinate to his lieutenant seems to kind of go along with all of the other misconduct that he's alleged to have engaged in, because, you know, each one of those is kind of him being arrogant.
Then exactly 1 week later, Cole saw a man riding his bicycle at night without a light. The man wouldn't stop, so Cole sicked his dog on him. But Wink News has now learned from this email that there was what was called a community initiative in place, where officers were supposed to give warnings and free bicycle lights to people instead of arresting them. The Punta Gorda police ultimately settled with the man for $60,000, and over $120,000 worth of medical bills were written off by a hospital. The Punta Gorda police also hired an expert who determined that Cole did not do anything wrong.
I don't care what they say, you know, him allowing that dog to rip the chest wall out of a man who was driving without lights on a bicycle, that's insanity.
The dog bite issue got attention around the world, and Cole said he was receiving death threats. So he improperly accessed the state computer system to remove his name from public records. He got a slap on the wrist from Chief Tom Lewis, who, ironically, illegally accessed the same system himself 5 years earlier and got suspended.
As an attorney, I mean, the Florida bar would be smacking me around something fierce, because you can't just engage in constant misconduct. He's got 5 or 6 incidents of serious misconduct. He's still a cop.
We asked Punta Gorda police officials for an interview about this story, and we were told, quote, "The chief will not be providing an interview on the memos you referenced. Continuing the public discussion of Officer Cole's work product prior to the conclusion of both FDLE's investigation and our own internal investigation is unfair and possibly improper on our end." Now, after all of that, that's not the most egregious things these attorneys say Lee Cole has done. That involved a wrongful arrest. We'll have that tomorrow night in part 2 of this story. Dave Colbreth, Wink News Now.
these drugs and stuff like the German jails. They would have, we got I'm a Canadian originally, we got 7 times more.
Will you do me a favor?
What's that?
If you want to record me, I have no problem with that.
Right.
But this is not a public building.
Last time we were here, we already discussed it. They said we could.
But there are other people here that may not know that you're recording them.
Okay, last time I was here, I asked if I could record, they said yes.
I have no problem with it.
Right.
I believe the facility is probably in the same mindset as they were last time. But just out of common courtesy, let people know they're being recorded, please.
You're being recorded.
Well, wait till everybody's here.
You have to let them know, too. Are you running? He doesn't answer questions, I'm sorry.
Can't answer questions?
No.
You just did.
You did.
If you have any questions for me, you can talk to my attorney, Kevin Shirley.
I gotta meet Kevin, man. He's popular,
house.
man. He is popular.
No, but he was the lawyer for the guy that sold when I bought my house 18 years ago.
Mom, stay here next to you, buddy?
Yes.
Thank you.
Anyhow, should be interesting. Good. You're from Punta Gorda?
Oh, did you meet him yet?
So am I.
No, tell me you were Canadian.
This is John Sircan. This is Ian. This is the guy that's doing all the filming, going for public records requests and stuff.
Oh.
They like him. They like him so much they trespassed him.
They do. I'm very popular.
What was the latest video on? Looking for a trespasser, that Jim Mello.
Oh, Jim Mello was trespassed from a real estate office for causing a disturbance in there.
Mm-hmm.
Oh, yeah.
And
But the only record you got was 2015. That was the one?
Yeah.
Oh.
But they were giving the other guy like a hard time about getting the record, so I had to go down there and straighten those things out with him.
Yeah.
Hey, Tom, and by the way, we tried to get L.A. Daniels and the black people to come today. I'm totally serious. Totally serious. I said, let's meet here and have a conversation.
It's a shame.
It is. So.
The meeting's canceled. Maybe next month. It's going to be same time, same place?
The meeting's canceled?
Yes, sir.
Why?
We're the community.
Feedback from the Trabia Woods community.
We can't be part of it.
You're not members of the Trabia Woods community, no.
Oh my God, that's a good point.
You've got your number,
You
man.
just told me
It's a meeting to discuss in the community, and now it's canceled.
Yeah.
Wow.
But seriously, I really appreciate you gentlemen.
No, but you told me a few minutes ago it's here to discuss a community discussion meeting, and now it's canceled.
Meeting's canceled, yes, sir.
Because I thought it was a community discussion meeting. That's what you told me a few minutes ago.
Yeah, we're members of the community. We like to be heard.
I appreciate it. Thank you guys for coming.
When will Cole face justice? Will Officer Cole ever face justice, Mr. Lewis?
That's a great point. Ask again.
Will Officer Cole ever face justice, Chief Lewis?
What about Officer? What about Tom Lewis? So what do you want to do? Go for coffee? Let's not waste the time. I'm shocked too, man.
He just told me
that you're going to have a meeting, right?
And I says, what is it about? And he says, it's just a community to discuss things in the community.
Right, he wasn't specific on which community, though.
Yeah, that's crazy.
But he just said community.
Exactly.
I says, what is it, about? And I says, well, that's great. That's what we should have.
It ain't worth it.
Okay.
Once they've got their mind made up.
All right, so what do you want to do? Let's not waste this. You want to do coffee somewhere or what?
Sure.
Harry, where's the closest place for coffee?
We could have just used this community center. We don't have to have anybody here.
I can't.
That's what I can't figure out. This is a public place.
Mm-hmm.
Why do you don't even need any kind of permission to
Right.
I don't understand that.
He's supposedly saying I do have the right to film, but I'm supposed to let everybody know.
I don't believe that's true in Florida. what God they're talking about.
That is true.
What kind of trust is that?
So Ian, let's not waste it. Let's do coffee somewhere. Wait. All right, so John, you want to do coffee somewhere then? Where's the closest? Hey, I'm shocked too. Totally shocked. I'm totally shocked, man. So what do you want? You want to follow us or?
Yeah, I'll follow you. Yeah.
All right, we're down here. I'm in the white convertible.
Okay, I'll follow you.
So where do you want to go for coffee? Let's not waste it.
Whatever you decide, it's favorite car. Yeah, I'm just too easy to get along with, man.
He just shut the meeting down. He said we're not from the community, so he canceled it. So let's not waste it. What you want to do? Let's do coffee somewhere.
I'd give it about 2 or 3 minutes. These two just showed up for the meeting.
I know. Well, now 2 black people just showed up from the community, so are they going to have a meeting? I know, that's why he said maybe wait a minute. Oh, have you ever seen anything like that?
Yeah. Oh yeah.
Oh, all right.
Oh yeah.
Are you here for the meeting? Are you here for the meeting? Hey, I think we got a meeting, man. We got another one. Yep. Your door. Okay, he still canceled it? All right, can I give you my card then? Hey, the reason why I showed up and the reason why he's freaking out, I unfortunately experienced the corruption here myself. So 3 years ago, I started Charlotte County COPWATCH. I was the guy that was in the newspaper and all 3 channels where they illegally looked me up on the David system. Not to bring me flowers, but to do bad things because I'm exposing the corruption here. So that's why I think I'm shocked. He shut it down. So we need cops. You know we need cops. I know we need cops. We're trying to show people that we're here. You can hold them accountable. You can do different things. You know what I mean? Is it all right if I give you my business card? All right. So in 3 years, by the grace of God, I'm a Christian. The YouTube channel went nuts. 40 million views. 38,000 subscribers. In fact, I'll even give you my regular card. So I'm sorry that he did this. We seriously are here. We need police, but we were just here to let you guys know that we're here. If you ever have, if you ever need any help, investigating anything, or if you need a story put out, because internal investigations won't do anything. We were the ones that helped break the dog mall story. We're also the ones that did in Collier County, 7 sheriffs beat the crap out of a white guy. He was in the hospital for 3 days. We broke that story. So we really are trying. Okay. We're trying to help. And sorry that it shut. We are shocked that he just killed it like this.
Okay.
So what was your name?
Reverend Brown. Reverend Howard.
Please get a hold of me, man. Do you guys got a card? I'm shocked. I really, really am. This guy right here, John Surcan, he helps the homeless over in Charlotte County. So he's going to let you guys know that he's here too. So he helps people there. In fact, you know what's crazy? He's the one the guy that supposedly got away from the sheriff at the water and hung himself. That's his landlord. He knows the guy. This wouldn't have happened. Like the guy said, he knew the guy. He didn't hang himself. You know what I mean? 65. So, anyways, I'm sorry that it bombed out. All right. Oh, are we filming? He was supposed to be. That's what I told him.
So why don't you want to move it up? L.A. Daniels.
Do you not value our opinion?
All right.
Is Officer Cole ever going to face justice, Mr. Lewis?
Why, who are you with? Just a regular person? That's fine. I don't answer questions.
I'm a regular person. Hey, Andrew, I wanted you to meet David. This is Dick's friend.
Okay.
Andrew. Who are you, a regular person?
No, I actually am. I'm
not a regular person?
Careful! Careful! Hey, let's not waste this. Let's do coffee. What's the closest thing to here for coffee? Here's my card. Because Sirkan's here and everything. You didn't even get to meet him. He helps the homeless in Fort Charlotte.
Oh, okay. How you doing? Hi. How you doing? Yeah.
Okay, where's the closest place for coffee?
See you later, man. It was a short meeting. Sorry, I didn't get more time.
I'm not sure. Let's go over here and we'll all talk.
All right, John, we're gonna discuss over here what we're gonna do. But be careful for those bike racks. You almost got it.